Your physician has asked you to watch this video because you've been provided with an arbitration agreement to resolve medical malpractice claims. I'm Michelle Miller, and today we're going to go over some of the important points of the agreement. Your first question might be, why is your physician asking you to sign this arbitration agreement? Well, medical malpractice lawsuits are often very lengthy and expensive for all parties. The high cost of malpractice lawsuits greatly contribute to the rising cost of health care. As a result, many physicians have been forced to raise their fees, reduce their practices, or leave Florida altogether, threatening patients' access to medical care. Arbitration is a relatively informal process of resolving disputes that is an alternative to the traditional court system. Through arbitration, patients and physicians both benefit because they are able to more promptly resolve malpractice claims and with less expense to all parties. It's very important that you carefully read this agreement, as information contained in this video will describe the arbitration agreement that your physician will ask you to sign. Your physician wants you to understand that you have the right to have all your questions answered to your satisfaction about this arbitration agreement. The agreement that you've been asked to sign will confirm that you understand the terms of the arbitration agreement and that you have no unanswered questions. Before the parties arbitrate a medical malpractice claim, the agreement requires the parties to first follow Florida Statutes Chapter 766 with regard to the pre-suit screening of medical malpractice claims. This screening process ensures that a medical malpractice claim is fully investigated so that those involved have an opportunity to resolve legitimate claims at an early stage, which again saves the parties time and money. Florida Law Chapter 766 also provides the opportunity through two separate statutes to arbitrate medical malpractice claims where a physician is willing to admit liability. If a medical malpractice claim is not resolved at the end of the pre-suit screening process by settlement, or if a physician is unwilling to admit liability, the dispute will be resolved by this arbitration agreement. How does the arbitration process work under the agreement? By signing, you agree to give up a valuable right, the right to have any potential medical malpractice claims resolved in a traditional court. Instead, a panel of 3 arbitrators resolve all medical malpractice claims. The process starts with a notice from one party to the other demanding arbitration. The patient and the physician would each name one person to serve as an arbitrator. An arbitrator is like a judge in that he or she listens to the evidence presented by both sides to decide whether malpractice has occurred. These 2 arbitrators would pick a third arbitrator. This panel of 3 would then set up rules about the witnesses and evidence each side could present, and they would set up the schedule for the arbitration. If necessary, the arbitrators could issue subpoenas to compel witnesses to appear at the hearing or to obtain documents or other evidence. Of course, at the arbitration hearing, you will still have the right to be represented by your own attorney. Each party will have the opportunity to present evidence and witnesses and can cross-examine the other party's witnesses. All 3 arbitrators will listen to the evidence and participate in the decision. They will apply the same law that a court would apply, but the procedural rules are more relaxed and the hearing is less formal than a trial. Based on the evidence and the law, the arbitrators could award any amount for damages that a court could award, but whatever the arbitrators decide will be final. This means whether they decide in the patient's favor or in the physician's favor, both parties agree to honor the decision. Neither party can go to court to appeal the arbitrator's decision except on very limited grounds. This is why they call it binding arbitration, because both sides are bound by the arbitrator's decision. The cost of the arbitration will be split between the patient and the physician. The arbitration agreement applies to malpractice claims associated with both past and future care and treatment. Also, if you sign this agreement but choose to go to court anyway, the agreement says that the arbitration proceeding can go ahead without you, and you'll be bound by the arbitrator's decision even if you don't participate. You should also know that this agreement applies to your spouse, children, or representative. For example, if something happened to you and your spouse thought that it affected your relationship, your spouse would ordinarily have a right to bring a lawsuit over that fact. By signing this agreement, you are also saying that any claim by a relative or representative relating to your medical treatment would be resolved through arbitration as well. Your physician is concerned about the effect that lengthy and expensive malpractice lawsuits are having on the cost and availability of health care in Florida. arbitration of malpractice claims is a quicker and more cost-effective means of resolving disputes, which is a benefit to both patients and physicians. The benefits of arbitration will help your physician from having to raise fees, reduce the scope of practice, or abandon the profession. These decisions will have an effect on the cost and availability of health care in Florida. Again, if you have any questions, please be sure that they are answered to your satisfaction before you sign the agreement. Thank you very much for giving me a few minutes of your time, and I hope you have a great day.